Hello learners, I welcome you all to the 38th lecture for this course on International Investment Law and the Environment. So in this video also we will be looking at a case, Copper Mesa Mining Corporation versus Ecuador. So this case involves an environmental regulatory measure and that was challenged by an investor. So as you know, in the past videos also we've been discussing about cases where environmental regulatory measure was challenged. So this video also follows the same trend where we'll be discussing about Copper Mesa versus Ecuador case. In Copper Mesa versus Ecuador case, there was a mining corporation called as Copper Mesa Mining Corporation, and this was a Canadian corporation and that was established under the laws of British Columbia. So this company, this corporation was earlier called as Ascendant Copper Corporation but later renamed to Copper Mesa Mining Corporation. So this fact is important because when we discuss the facts, I may use the word Ascendant Copper Corporation or certain other companies like Ascendant Ecuador that was established in Barbados or Ascendex and all of these. So cumulatively you can, we can refer to them as the claimant itself irrespective of which corporation did what act, because subsequently we could see the concessions that are involved in this case were all granted to Copper Mesa Mining Corporation, right? Okay, so what were the concessions that were involved in this case? So there were primarily three concessions that were involved in this case. One was Junín concessions. All these three concessions were in Ecuador itself. Junín concessions because this concession was located in the Junín area of Ecuador. And secondly, Chocha concessions. And third one is Telimbala concession. The first two concessions at the time of the dispute were already acquired by the claimant. But with regard to the third concession, Telimbala concession, the claimant had an option to acquire that particular concession. So, but primarily these are the three concessions that are involved in this particular case. The dispute revolves around these three cases only. Okay, so let us look at the location of these three concessions, where it was located. As you can see, Junín concession was located in the Junín area and that extended over 12,900 hectares of land, and this Junín area was located in something called Intag area. Intag area was a very remote part in the western province of Imbabura in the canton of Cotacachi. So Junín area, on the one side, it has Intag river as its boundary and that was partially adjoined by the protected forest of Chontal Intag. Then on the other side you see Cotacachi Cayapas Ecological Reserve, and also on the other side you see protected forest of Pajas de Oro. So this is how the Junín concession was surrounded by these ecologically sensitive area. Even Junín area also had a tropical forest, steep sided mountains and hills, and there were very little industrial activity here. When we look at the population who resided here, the population in Intag area were primarily from Cotacachi, Apuela, Penahera, Garcia, Moreno communities. These are actually the bigger communities. Other than these bigger communities, there were people from smaller communities also like Chontal Alto, Chontal Bajo, La Armenia, Chalguayacu Alto, Chalguayacu Bajo, Junín, Collaje, La Magnolia, Alto Mira, Barcelona, El Rosario, El Esperanza, La Liberated and Cerro Peraldo. So La Liberated and Cerro Peraldo were actually the population that were residing within the concession itself. So just because there were many communities and many people were residing, the award merely referred to population in Junín concession without specifically talking about the communities itself. Similarly, if we see Chocha concession, that was in the area of Cuenca canton of Azuay province in southern Ecuador, and this concession extended over approximately 3,000 hectares. Similarly, Telimbala concession was also located in the canton of Chimbo in the province of Bolivia south of Kyoto, and this extended over 4,200 hectares. The development of mining concessions in Ecuador started with one study that was published by General Direction for Mines, DGGM, the abbreviation is DGGM. This study was published in 1991. And if we look at this particular study, they sort of preliminarily said there are possibility of mining activities that can happen here. So what happened was Japan and Ecuador signed a cooperation agreement in order to see if there can be mining activity that can be conducted if there are resources here. Pursuant to this cooperation agreement signed between Japan and Ecuador, we do see the Japan's International Cooperation Agency starting to explore the possibility of mining activities in Ecuador. So the first study, DGGM study, was published in 1981. 1991, Japan and Ecuador signing an agreement. Subsequent to that, Japan International Cooperation Agency as well as Japan Mining Agency, all of them are conducting a study in Ecuador with regard to the possibility of exploring resources through mining activities. And when this was happening, by March 1996, large deposits of copper was found in Junin concession, and somehow unofficially this report became available to the public. Once this report became available to the public, what happened was there were some protests. Some people did not want mining activity to happen because they thought that it would be detrimental to the environment as well as to their, it would have some social effects as well. So there were people who were opposed to mining, but at the same time there were people who were pro-mining as well. So we do see the local population was divided. Some people wanted the mining activities to be carried on. Some people did not want the mining activities to be carried out. So March 1996, the report of copper becomes public unofficial. It is not officially released to the public. Unofficially it becomes public. April 1996, Canada and Ecuador signing a bilateral investment treaty. Around this time, what's happening was there was this company Bishi Mittal. Bishi Mittal is one of the corporate subsidiary of Mitsubishi. Mitsubishi is something that you might know. So Bishi Mittal is a subsidiary of Mitsubishi and was a contractor for Japan International Cooperation Agency, and it was undertaking certain activities here. Remember the cooperation agreement between signed between Japan and Ecuador. Pursuant to that, Bishi Mittal, a contractor for Japan's International Cooperation Agency, was doing some activities, and then they faced some clashes with the local population who are against mining. So mining, let's for the sake of convenience, we'll call them as anti-mining members. So anti-mining members of the local population started having clashes with Bishi Mittal. Now what Bishi Mittal had endured through these protests was one of their mining camp was actually burnt down, and it was said that the anti-mining members of the local population burned down the mining camp. Now another thing that had happened was there was a landowner, he was shot dead, and this landowner was somebody who had actually refused Bishi Mittal from entering his land because for whatever reasons he refused Bishi Mittal from entering his land, and later he was found 2 days later he was shot dead. So there was this anti-mining NGO, non-governmental organization. They said the landowner's death is something that can be attributed to a paramilitary squad that was hired by Bishi Mittal. Right, so that was the thing, the clashes that are happening. So by mid-1997, Bishi Mittal abandoned the project because of the local hostility, and it had gone from here. So now what we see here is Ecuador comes out with an environmental regulation, an executive decree, which makes an environmental study to be a very necessary thing even before exploration stages of the concession had happened. This is happening in September 1997. Then Ecuador also adopts a new constitution. As per the new constitution, huge powers were given to the local government itself. These were the changes that had happened with regard to the normative framework governing the concession. What we see here is Bishi Mittal abandoning the project and going, and there were some changes to the normative framework. We see that an executive regulation had come up and the new constitution had come up, which conferred a lot of powers on local government. In that context, there is this local Ecuadorian national. he acquired 2 concessions, Golden 1 and Golden 2 concessions from the Ministry of Energy and Mines. And once he acquired the concession, then that again triggered the local protests. There were a lot of people who were against the fact that there was granting of concessions. The fact is, he was actually an Ecuadorian national only. Even then, the local population felt that the concession should not have been given to him. Then they approached the local court of Imbambura. So here, the court of Imbambura had a very interesting take on this granting of concession. The court of Imbambura actually ruled against the granting of these genuine concession to the Ecuadorian national Dr. Roque Bustamante. The court even observed that the mining concession which was granted by Pichincha Regional Mining Directorate to Mr. Roque Bernardo Bustamante Espinoza would have brought serious consequences and impacts, such as on an environmental and ecological level in rivers and streams, and to the flora and fauna, and social impacts and others. Moreover, the court found that it was not apparent from the proceedings whether the Pichincha Regional Mining Directorate had taken into account the provisions of Article 88 of the National Constitution and the criteria. What is that talking about? The new constitution? The criteria of the community, was it considered or not? So because the court observed that the inhabitants of the 6 parishes of the intact in this canton have resolutely objected to the said mining concession, then how can that particular criteria be fulfilled? So what the court of Imbambura said was, they ordered for the cancellation of the mining concession. So court of Imbambura had cancelled the mining concession, but the same was appealed to Ecuador's constitutional court. What the Ecuador's constitutional court did was, they reversed the decision of this court of Imbambura. So finally, the cancellation of the mining concession was overturned by the Ecuador's constitutional court. Now, Accidents, which was one of the corporation from whom eventually the concessions will come to the claimant. So, for the sake of our convenience, we will use the name claimant so that we don't get confused with different names of different corporation. So, what the claimant had here was done was, the claimant had acquired the concession of Chaucha. Claimant had applied, the Accidents had applied for concession of Chaucha, and the same was granted, because before the Accidents had applied for Chaucha concession, we could see a favorable decision was given in favor of the person who had earlier received the Golden 1 and Golden 2 concession by the Ecuador Constitutional Court. So maybe the Accidents felt that the time was ripe, they applied for Chaucha concession and that was granted to them. So Accidents went ahead and purchased Golden 1 and Golden 2 concession from the Ecuadorian national also. So Accidents had got Chaucha concession as well as Golden 1 and Golden 2 concession in the Junin area also. That also came to Accidents. Later on, what happened was, Accidents had filed many lawsuits against certain members of the local population who were against mining. Criminal cases were filed. So then back and forth, the filing of criminal cases between Accidents and its employees on the one hand and the anti-mining members of the local population on the other hand kept on happening. So eventually what happened was, Accidents transferred its shares in these concessions to Accident Ecuador, and Accident Ecuador transferred the concessions to Accident Ecuador Barbados, the company that is based in Barbados. From the Barbados Corporation is where Accident Copper Corporation buys all the concessions, becomes 100% owner of all the shares relating to the concession. So Accident Copper Corporation becomes 100% owner of these concessions, and later it changes its name to Copper Mesa Mining Corporation, and that is why you see the name of the case as Copper Mesa versus Ecuador. Right, so Accident Copper Corporation acquires all of these, but the problem between the anti-mining members and the claimants did not stop there. Then there were many cases that were filed. Eventually what had happened was, there was a meeting that was called between anti-mining members pro-mining members, MEM, Ministry of Energy and Mines, and the claimants, and all of them sat and sought out certain things, because before this attempt, Accent and the claimant directly tried to engage with the local community, and that was all unsuccessful. So a broader meeting where all the relevant stakeholders were called, MEM was called, so basically government is represented and the investor was represented, anti-mining members and pro-mining members, all of them were part of this meeting. So all of them, different stakeholders put forth their point, and finally there was an agreement that was signed, that was tripartite agreement, and it contained certain terms. Once the agreement was signed, it was expected that every stakeholder will sort of pull their weight under the agreement. This was expected. Now, what had happened was the local population had a problem that the investor was not implementing the things that was agreed in the tripartite agreement, and they have communicated the same to MEM, Ministry of Energy and Mines. So, Ministry of Energy and Mines wrote a letter to the investor asking the investor to suspend the mining activities, but they didn't mention anything about the tripartite violation. What was mentioned was suspend the activities in light of socio-environmental conflict that is present in the region. Now, MEM was later replaced by Ministry of Mines and Petroleum. When Ministry of Mines and Petroleum came into the picture, what the Ministry of Mines and Petroleum did was, they wrote a letter to the investor asking the investor to suspend the activities for the reason of violation of tripartite agreement. This is the first time the investor was communicated that they have to suspend the activities because they have violated the tripartite agreement. Then there was another meeting that was called for these stakeholders only, pro-mining representatives, anti-mining representative, ministry representatives, and the claimant's representatives. So in that meeting, the claimant stated that it had suspended all its activities in the Junoon concession. So now what had happened was, there was this regional directorate. Remember, the regional directorate was given a reference to in the judgment that we just discussed. So that regional director, what he did was, he issued a resolution declaring suspension of mining activities. So we can call this as suspension resolution. So once a suspension resolution was issued, and the claimant appealed this particular resolution before the ministry, and then again a new regional mining director takes office, and this particular person, what he does is, he issues a resolution nullifying the concession granted in Junoon concession. So after this, then we could see the claimant appealing the nullifying resolution before the National Mining Director. This is what had happened. Meanwhile, the new regional mining director, what he does is, he files a case before the court, constitutional court, challenging the mining law itself. So meanwhile, there was one mining mandate that was issued by the Ecuador Constituent Assembly, and this mining mandate actually empowered Ecuador to terminate the concessions which were in the exploration stage without giving any compensation. Once that was passed, then the claimant suspended the activities in Chaucha concession as well. And now what had happened was, with regard to Junoon concession, remember the appeal was made by the claimant before the National Mining Director. So the National Mining Director revoked the nullification resolution and restored the concession rights to the claimant itself. So restoration of concession rights were done to the claimant at this was a factual circumstance of this particular case. Now what had happened was, I mean, they had anyway suspended the Chaucha concession. Now here there is restoration of mining rights that had also happened, that had taken place, but there were again many clashes that were happening with the local population. So the mining mandate was very problematic to the claimant, because mining mandate had authorized Ecuador to terminate the concessions without paying compensation. So this was the level where the factual circumstances were when the claimant had decided to file a case against Ecuador. So in the next segment, we will look at the initial objection and then we will look into the merits of the case. So I hope you've understood the factual circumstance of the case. In any mining case, I mean any case which involves a mining concession, the facts are always complicated. So there were many measures taken, many revocation and all of that. But these are the very essential facts with regard to this particular case. Thank you.